Welcome to AudioCert, where the official study guides are brought to life. Today, we are strapping in for a deep dive into CCSP Domain 6, Legal, Risk, and Compliance. Now, for many people in tech, this domain, well, it feels less like technology, doesn't it?
Oh, absolutely. It's more like navigating a maze, a legal maze, maybe a geography puzzle mixed in.
Exactly. So our mission here is to, gain some fluency. We need to understand the basic legal stuff, the frameworks,
Right.
and figure out why global privacy causes so many headaches, so much international conflict.
And the practical side, too, like forensics, auditing in the cloud. It's different.
It really is. It's essential because cloud computing, by its very nature, it's everywhere, isn't it?
That's the core issue. You've got data centers scattered across continents, shared resources. Demand dictates location, not necessarily local laws.
So anyone operating in the cloud is juggling what? Local rules, state laws, federal regs?
International treaties, sometimes all at once. You've got to protect data across multiple jurisdictions, and often those laws directly conflict.
Sounds like legal quicksand, not resource optimization.
Yeah, it can feel like that.
Okay, so we need to lay the groundwork, give you, our listeners, the background needed to navigate these complex waters, to give solid advice when inevitably you face a conflict of laws.
Precisely. Let's unpack that core structure first. Before we get lost in all the acronyms and specific regulations, we need the foundation.
Okay, let's do it. Unpack the foundations. We often jump straight into things like HIPAA or GDPR, but we need those building blocks first, right? The main types of law that, well, shape how we operate. We can use the U.S. system as a kind of template here, acknowledging it varies globally.
Makes sense. So the three main bodies are criminal law, civil law, and administrative law. They basically define the fight, the process, and what happens if you lose.
Okay, criminal law first.
Right. Criminal law is where the government steps in. It acts for the public when someone, a person, a group, an organization violates a specific law, a statute.
So statutes are the written rules from lawmakers saying don't do this, like theft, fraud.
Exactly. Or, increasingly relevant for us, certain kinds of privacy violations.
And the stakes here are, well, they're huge. It's punitive.
Extremely. Punishments can range from fines all the way to prison time, or even, in some jurisdictions, the death penalty.
Wow.
And the process is called prosecution. Only the government can prosecute a criminal case. It's often seen as the highest stakes because, freedom or significant assets are on the line. Society seeking restitution.
So how does this hit cloud security directly? I mean, beyond the obvious stuff like catching cybercriminals.
This is where the risk calculation changes completely for compliance. See, in the U.S., most privacy violations tend to fall under civil law. You pay damages.
Okay.
But internationally, and this is key for anyone studying for the CCSP, privacy breaches can be treated as criminal acts, especially with regulated data, say from the European Union.
So handling EU citizen data, a slip-up isn't just a lawsuit.
It could lead to criminal prosecution for key people in the company, not just a fine. That's a massive difference in risk.
Definitely something to keep front of mind. Okay, second pillar, civil law.
Right. Civil law deals with private disputes between individuals, between companies, organizations, things like property lines, who's liable for an injury, marriage.
And the big one for cloud?
Contract law. Absolutely essential.
So if my cloud provider doesn't meet their uptime promise in the SLA, that's a civil issue.
Correct.
What happens then? What's the punishment?
Usually it's about making the injured party whole. So restitution, paying monetary damages, or maybe a court order telling the other party they have to do something specific. But crucially, no jail time for breaking a contract.
And the entire cloud ecosystem runs on these agreements, right? SLAs, compliance contracts.
It's the backbone. Contracts are these agreements for mutual benefit. If one side doesn't hold up their end, like that data center uptime example, that's a breach.
Which can lead to a lawsuit seeking relief.
Exactly. It's what keeps providers accountable to their customers, theoretically.
Okay, third one, administrative law. This one always feels a bit fuzzier. Not always tied to a legislature or a normal court.
Yeah, that's because it's law made and enforced by the executive branch. Think government agencies, like the IRS making tax rules or the EPA setting environmental standards.
How do they get away with that, making laws and enforcing them?
Well, they're delegated that authority, and they often have their own internal systems, rulemaking processes, enforcement agents, even their own courts and judges.
Can you give a cloud-relevant example? Maybe the FTC. The Federal Trade Commission.
Perfect example. The FTC enforces consumer protection laws. That includes data privacy and security. especially if a company lies about how secure they are.
Ah, so false advertising about security.
Exactly. If the FTC finds a cloud provider or even a customer is breaking security rules or making false claims, they don't need to wait for prosecutors or lawsuits. They can launch their own enforcement action.
Impose fines, mandate changes.
Steep fines, yeah. And they can force major changes to security programs. All done internally within the agency. Gives them huge leverage over how businesses operate. And state attorneys general often do similar things at the state level for privacy stuff.
Okay, got the 3 types. Now, sticking with the U.S. model for a sec, there's the state versus federal law thing. How do we handle conflicts? Like when one says one thing, the other says something else.
Generally, federal law wins out over state law, especially when it involves business across state lines, interstate commerce.
But there's always a but.
The rule you have to live by in security and compliance is follow the strictest law. If a state has a tougher rule, maybe like some California privacy laws.
Which are famously strict.
Right. If those are tougher than the federal equivalent and you do business in California, you follow California law, the most stringent one applies.
Good rule of thumb. And we need to be careful with words. State in the U.S. means California, Florida.
Member entities of the Federation.
But internationally, state usually means a whole country like France or Japan.
Precisely. You have to be crystal clear when talking global cloud jurisdiction. Are we discussing a sovereign nation, an international state, or a U.S. state? Big difference.
Okay, foundations are set. Let's move into the specific U.S. federal laws that really impact cloud security day to day.
Sounds good. These have a huge footprint.
Let's start with healthcare. IPA-TE, the Health Insurance Portability and Accountability Act of 1996.
Right. IPA protects electronic protected health information, or EPHI. It started out focused on just letting patients get their records and keeping insurance portable.
But it grew, right?
It really did. The key parts for us now are the 3 main rules. The privacy rule that sets limits on who can use or see EPHI. The security rule that mandates specific safeguards. Administrative, physical, and technical. And the breach notification rule, which says you have to tell people and the government if their EPHI gets compromised.
And the HIC Act pushed this along back in 2009.
Big time. HITech basically paid healthcare providers to go digital, switch from paper to electronic records.
Which means suddenly there's way more EPHI stored digitally.
In data centers, in the cloud, exactly. And that massive shift necessitated the tougher security rules we have now under HIPAO, enforcement. That's the Department of Health and Human Services, DHHS, and their Office for Civil Rights, the OCR. They do audits.
And the penalties aren't just fines, are they?
No, they can be really severe. Fines are tiered, depending on how negligent you were.
Yeah.
But for really bad violations, especially if someone intended to steal and sell EPHI, you're potentially looking at Tier 3 criminal violations. That could mean up to 10 years in prison.
Wow. So a privacy failure isn't just an IT mistake.
It can be a serious crime.
Yeah.
Prosecutable.
Okay, moving to finance. GLBA. The Gramm-Leach-Bliley Act of 1999.
GLBA. This one kind of shook up the financial world, let banks merge with insurance companies, things like that. But the trade-off was a big security requirement: protect customer account information.
And for cloud, the key piece is
the safeguards rule. This is critical.
Tell us about that. How does it hit a cloud service provider, a CSP?
It mandates that financial institutions, and by extension, anyone handling their data, like a CSP, must have a written information security plan. They need to name an information security officer.
Okay.
And crucially, they have to implement a program to keep non-public personal information safe and confidential. For a CSP hosting financial data, this translates to strict requirements.
Like what?
Things like strong access controls, robust encryption for data, both sitting still and moving, continuous monitoring, regular security testing. You have to guard against insider threats, unauthorized data exfiltration. GLBA demands it.
Got it. Okay, next up, corporate responsibility. SOX, Sarbanes-Oxley Act of 2002.
SOX, born directly from those huge accounting scandals, right?
Yeah.
Enron, WorldCom.
Yeah, massive failures.
So SOX applies to publicly traded companies. Its goal is transparency, accuracy, and financial reporting.
But how does that filter down to, like, the IT department or the cloud provider they use?
It mandates formal IT governance. The big one is Section 404. It requires company management to set up and maintain internal controls over financial reporting. And this is key. An external auditor has to sign off on how effective those controls are.
So for IT, that means?
Formal, documented processes for everything touching financial data. Number 1, change control. Any system change needs rigorous documentation and approval. Can't just patch a server informally.
Okay.
Number 2, Segregation of duties. No single person should be able to, say, initiate a payment and approve it, or make a critical system change without oversight.
Right, checks and balances.
And number 3, log retention and integrity. You need to keep secure, long-term logs that prove your controls are working. If you use a cloud provider, your SOX compliance, your Section 404 report, heavily depends on their controls and their audit reports.
And the SEC, the Securities and Exchange Commission, they enforce this.
They do. They set the standards, enforce them. And SOX also really hammered home the idea of auditor independence. The auditors checking the books, checking the controls. They can't have any conflicts of interest, financial or personal.
Makes sense. Okay, now for the law that seems to cause the most international friction, the Cloud Act, clarifying lawful overseas use of data.
Yeah, the Cloud Act. This one is controversial. It essentially gives U.S. law enforcement the power to compel U.S.-based tech companies, CSPs included, to turn over data requested with a warrant.
Okay, standard procedure.
Here's the kicker. Even if that data is stored in a foreign data center, and even if handing it over violates the local laws of that foreign country.
Whoa. So a U.S. cloud provider operating legally in, say, Germany could be forced by a U.S. court to break German privacy law.
That's the nightmare scenario. It puts them in an impossible position.
Is there any defense? What can a good provider or their customer do contractually?
That's the million-dollar question. First, the provider needs to figure out if they even count as a U.S. person under the Act. But contractually, the data controller needs to push hard.
For what?
For clear contract language. The provider should commit to fighting the warrant in U.S. courts if it conflicts with local law. They should promise to notify the customer immediately. Explore legal challenges based on where the data is, who the user is. The Cloud Act isn't a blank check. There's still some due process, but it definitely puts the burden on the provider to resist.
Heavy stuff. Lastly, for the U.S. section, let's mention FedRAMP. It's not a law, right, but crucial.
Right. FedRAMP is a U.S. federal program. It standardizes the security assessment and continuous monitoring for any cloud service that wants to work with U.S. government agencies or contractors.
So it sets a baseline security level for government cloud use.
Exactly. It's known for being incredibly rigorous, a tough authorization process, and it requires ongoing monitoring. Because it's so thorough, it often acts as a pretty good benchmark for high-security commercial cloud deployments, too. If a provider is FedRAMP authorized, that says something.
Okay, let's shift focus now. Go global. We talked about geography being the enemy of cloud security. Why is international data privacy such a massive, fundamental clash?
It really boils down to two totally different philosophies about data. In the European Union and many other places, personal privacy is seen as a fundamental human right. It's often written right into their constitutions.
Okay, a human right, whereas the U.S.
The U.S., as we saw with HIPAA and GLBA, takes more of a sector-specific approach. Privacy is treated more like a consumer protection issue or a requirement for certain types of business. There isn't one single overarching federal privacy law guaranteeing it as a right.
And that philosophical split shows up immediately in how consent works, right? Opt-in versus opt-out.
Absolutely. The European model is generally opt-in. You need explicit, clear, affirmative permission before you can collect or use someone's personally identifiable information, their PII.
Permission first.
Permission first. In the U.S., the more common model is opt-out. Sharing data is often the default setting. The individual has to actively take a step, check a box, send a form to stop their data from being shared.
Let's use that banking example. I open an account in the U.S.
You're probably opted into sharing unless you find the form and opt out.
But if I open an account in the EU...
The bank basically can't do much with your data beyond what's strictly necessary to run your account, unless you actively check a box saying, yes, you have my permission.
It's complete flip. Total change in responsibility.
Total inversion.
Yeah.
And the definition of PI itself is often much broader outside the U.S. too. The EU, for instance, often considers things like mobile numbers, IP addresses, even web cookies as PII, if they can be linked back to a person.
If you can track someone, it's protected.
Pretty much. Which brings us to the big one. The legislation everyone talks about. GDPR, the General Data Protection Regulation.
And this applies to basically everyone.
Almost.
Yeah.
It applies to any organization anywhere in the world if they collect or process the PII of any EU citizen. Your company could be in Brazil, but if you have EU customers, GDPR applies to you.
Wow. Okay. What are the core ideas?
GDPR is built on several key principles. Many align with the OECD framework. Things like notice, be transparent about what you collect. Choice, get consent. Purpose limitation, only use data for the reason you stated. Access, let people see their data. Integrity, let them correct mistakes. Security, you must protect the data. And strong enforcement.
Okay, those sound reasonable, but there's one principle that's famously difficult.
Ah, yes. The right to be forgotten, or more formally, the right to erasure.
What does that mean practically?
It means an individual can tell any organization holding their PII, delete it, all of it, now. And the organization has to comply and destroy all copies.
All copies? How is that even possible in the cloud? With backups, replication?
That's the operational nightmare. It's incredibly tough in distributed systems. You need rigorous processes to find all instances, delete them, and then prove you deleted them. Auditable proof. It's a massive challenge for cloud storage providers.
You mentioned GDPR caused friction, partly aimed at U.S. companies because the EU felt U.S. government safeguards weren't strong enough. So how does a U.S. company legally comply with GDPR?
There are a few ways. The first, which got complicated and legally challenged, was the Privacy Shield. It was a voluntary program where U.S. companies basically promised the U.S. Department of Commerce they'd follow GDPR rules.
Okay, promised. What else?
Companies can create very detailed internal policies, either binding corporate rules, BCR, or use standard contractual clauses, the SEC.
So they basically write their own internal GDPR rulebook.
Pretty much. But they then have to get those rules approved by the Data Protection Authority in every single EU country where they operate or whose citizens' data they handle.
Every country. That sounds like a ton of paperwork.
It's a huge administrative lift. But it ensures their internal controls meet the standards validated by each local EU authority.
Now, understanding the roles GDPR defines is crucial for risk, right? Data subject, controller, processor.
Absolutely vital. The data subject, that's the individual whose data it is, you, me.
Okay.
The data controller, that's the organization deciding why and how the PII is processed. Think of this as the cloud customer. They own the relationship with the data subject.
And the processor.
The data processor is the organization that handles the PII on behalf of the controller. They store it, manipulate it, process it according to instructions. This is typically the cloud service provider, the CSP.
Right. Now, the absolute killer question for anyone taking the CCSP exam. If there's a breach, unauthorized disclosure, who's ultimately on the hook legally under GDPR?
The data controller, the customer.
Wait, even if the breach was the fault of the processor, the CSP?
Yes. Even if the CSP messes up badly, the data controller faces the immediate regulatory scrutiny and potential fines from the EU authorities.
Wow, that's a massive burden. So let's use that example. Acme Corp uses Ostrich Cloud Services. An Ostrich admin steals Acme's customer data. Acme gets the fine.
Acme gets the fine and bears the primary legal responsibility under GDPR.
So how does Acme, the controller, protect itself? They can't just hope the CSP does a good job.
No way. It all comes down to the contract. Since the liability flows back to the controller, they need ironclad contract clauses with the processor, the CSP.
Like what specifically?
Number 1, strong indemnification clauses, making the processor promise to cover all the legal costs, damages, fines, if the breach was their fault, negligence, or malicious act.
Okay, make them pay if they mess up.
Number 2, right to audit clauses, giving the controller the power to inspect the processor's controls or demand specific third-party audits to prove they're actually following the GDPR rules continuously.
So it has to be a partnership, but the controller holds the ultimate risk.
Exactly. It's a compliance partnership built on a very clear understanding of where the legal liability sits.
Now, the EU recognizes some other countries as having adequate privacy laws, right? Makes data transfer easier.
Yes. Places like Australia, New Zealand, Canada has its PIPEDA law. Argentina, Japan, Switzerland, Israel. If a country is on that adequacy list, transferring data there from the EU is much simpler.
And what about APEC, the Asia-Pacific Economic Cooperation Group? They have a privacy framework, too.
They do, the APEC privacy framework. But it's important to understand the difference. APEC is focused on boosting trade, free markets.
So their framework is?
It's based on non-binding principles. The goal is to build consumer trust to help the economy, not necessarily government protection of fundamental human rights like GDPR. Different philosophy, different focus.
Okay, we've built the compliance picture. Now let's shift to when things go wrong. Legal action happens. How do we find the evidence in the cloud? We're talking eDiscovery, electronic discovery.
Right, eDiscovery. The formal process. Find, preserve, collect, review, and produce electronic evidence for court litigation or prosecution.
And the cloud makes this harder.
Exponentially harder. Think about traditional eDiscovery. You seize a specific server, a specific hard drive. You know where the data physically is.
But in the cloud.
You often don't. Data is pooled across shared storage, maybe copied across different countries automatically, moving between physical machines constantly. How do you pinpoint just one customer's relevant emails or database records?
Without grabbing data from other customers sharing the same hardware.
Exactly. Violating their privacy, their security. It takes specialized tools and often specialized external consultants who know how to navigate this multi-tenant environment without messing up the evidence or breaking privacy rules. Some providers offer eDiscovery as a service, a SaaS solution, to help.
And once you do get the data, preserving its integrity is critical. Chain of custody and non-repudiation.
Absolutely paramount. The chain of custody is the unbroken record, meticulously documented. Who found the evidence? When? How? Where was it stored? Who accessed it? Any changes made? Every single step.
From collection to courtroom.
From collection to courtroom. If that chain is broken, if there's a gap where you can't prove the evidence wasn't tampered with,
it might get thrown out.
It's likely inadmissible. And a solid chain of custody gives you non-repudiation. Meaning the parties involved can't later deny they took part in whatever the evidence shows. The proof is solid because the evidence handling was solid.
Okay, let's dig into cloud forensic challenges. What makes investigating in the cloud so tricky beyond just finding the data?
Well, many things. First, that data location ambiguity we mentioned, not knowing the physical location impacts which laws apply. Jurisdiction is key.
Right.
Second, the sheer scale. Just wading through massive amounts of data. Third, traditional forensic tools designed for physical disks often don't work well on virtual machines or complex cloud storage systems.
What about investigating live systems, like in infrastructure as a service?
That's another huge challenge. You might need to capture what's happening right now, data in memory, current network connections, CPU state. Capturing that live data without affecting other tenants on the same physical machine requires the provider's cooperation, specialized tools, and usually explicit contractual permission. You can't just barge in.
Are there standards to guide this? How do investigators do this properly?
Yes, thankfully. Cloud pros need to know the relevant ISO IE's 27000 standards for digital forensics. ISO IE 7037 covers identifying, collecting, acquiring, preserving digital evidence. Then you have 27041 for analysis, 27042 for managing the investigation, 27043 for the processes themselves. Following these shows you're acting with due care.
Let's revisit conflicting laws with that real-world example you mentioned, David Carruthers.
Right, the online gambling CEO. Perfect illustration of jurisdictional reach. He ran a UK company, operating legally there and in Costa Rica. But online gambling was illegal in the U.S.
And the U.S. couldn't easily extradite him.
So when he was just changing planes in Dallas, Texas, physically on U.S. soil, for a brief moment, U.S. agents arrested him.
Wow. They used his physical presence to enforce U.S. law for activities done elsewhere.
Exactly. It's a stark reminder. You're subject to the laws of any place you physically enter, even temporarily. And governments can be opportunistic in enforcing their laws globally. We see similar tensions when, say, China requires U.S. tech companies to disclose user data, creating direct conflicts with U.S. privacy expectations.
Okay, before we move off operations, let's clarify identifiers. Direct versus indirect.
Good point. Direct identifiers are obvious. Name, address, social security number, email, things that point straight to one person.
Okay, and indirect.
Indirect identifiers are trickier. These are pieces of information that aren't sensitive by themselves, but when you combine them, they can pinpoint someone.
Give us a cloud example. How could indirect identifiers unmask someone?
Okay, imagine a CSP logs these things. A user always logs in around 8 a.m. Central Time. Their web browser has a really unique configuration like a fingerprint. They always connect through a VPN server in Miami, and they always use specific tags like Project XDev on their virtual machines.
None of those seem sensitive alone.
Right, but that specific combination, 8 a.m. CST login, unique browser, Miami VPN, Project XDev tag, that combination might apply to only one person in the entire system. You've effectively identified them indirectly.
So anonymization means removing both types.
Yes. Proper anonymization requires stripping out not just the direct identifiers, but also enough of the indirect ones, or fuzzing them so you can't relink the data back to an individual.
All right, compliance frameworks are set, crisis procedures discussed. Now, proving compliance. Audits. How does the cloud mess up traditional auditing, and what reports do we actually need to trust?
The biggest immediate change is moving from physical to virtual. Old school auditing might involve finding a physical Cisco router, checking its serial number, pulling its config file
Tangible stuff.
in the cloud. The auditor is looking at software, virtual routers, virtual switches run by the hypervisor, software-defined network policies, completely different skill set needed.
They need to understand virtualization security now, not just network closets.
Exactly. And they need to audit the hypervisor itself, who has access to the underlying system that runs everything for all the tenants. If the admin managing that hypervisor is in another country, now you have geopolitical risk layered on top of technical access controls.
That complexity makes defining the audit scope absolutely critical, doesn't it?
Hugely critical. The scope document has to spell out precisely what is being audited. Is it just the IaaS compute layer? Does it include the platform services, the SaaS application itself, the physical network underneath? It changes dramatically depending on the cloud service model, IaaS, PaaS, SaaS.
And if you're a SaaS customer, you're mostly relying on the provider's audit for the lower layers.
Almost entirely. You can't audit Google's data center yourself. The scope might also be limited geographically. Maybe the audit only covers controls in the U.S. data centers, not the European ones.
What if the auditors don't get the info they need? If the company holds back evidence or access?
That's a major red flag. The auditor issues what's called a scope limitation, and that leads to either a qualified opinion, meaning the auditor couldn't verify everything, so the report isn't a clean bill of health, or, even worse, a disclaimer of opinion, where the auditor basically says, I couldn't get enough information to form any opinion at all.
So if you're a customer doing due diligence and you see a qualified opinion or a disclaimer,
Burn away, or at least dig much deeper. It signals significant risk.
after an audit, often there's a gap analysis. What's that?
The gap analysis compares where the organization is right now with its controls versus where it needs to be to fully comply with whatever standard or regulation they're aiming for. It identifies the shortfalls.
And who should do this analysis?
For auditor independence, which is vital, it really shouldn't be the auditors themselves offering specific solutions. And ideally, the gap analysis team should be separate from the department being reviewed to avoid bias. Objectivity is key.
Which brings us nicely to internal versus external audits.
Right. Internal audits are done by employees. They're useful for ongoing checks, finding issues early, but they can suffer from bias. People might not want to report bad news about their own department, or they might lack expertise or fear political fallout. So generally, weaker evidence for outsiders.
And external audits.
Done by independent third parties. They're usually more thorough, more objective. They often audit the internal audit function itself. That auditor independence we talked about, heavily pushed by SOX, is the cornerstone. No financial ties, no personal relationships that could compromise their judgment.
Okay, for cloud customers doing due diligence who often can't do their own physical audit, the key documents are the SOC reports, System and Organization Controls, from the AICPA SSAE 18 standard.
These are essential, absolutely essential. Let's break them down. First, SOC1.
What's that cover?
SOC1 focuses only on controls relevant to the client's financial reporting. If you're a security pro worried about data breaches or system availability, SOC1 is probably useless to you. It doesn't cover the security stuff.
Okay, so ignore SOC1 for security assessments. What about SOC2?
SOC2 is where the security action is. It reports on controls related to 5 trust services criteria: security, availability, processing integrity, confidentiality, and privacy. You pick which criteria are relevant.
And there are 2 types, Type I and Type 2.
Yes. The SOC2 Type I report looks at the controls as designed at a single point in time. It basically says, on January 15th, the provider had these controls documented. Interesting? Maybe. But it doesn't tell you if they actually work.
So it's a snapshot of intentions.
Pretty much. The SOC2 Type 2, now that's the gold mine.
Why is it so much better?
Because the Type 2 report tests the operational effectiveness of those controls over a period of time, usually 6 months or a year. It doesn't just look at the design. It tests if the controls actually work consistently. This gives you a much more reliable picture of the provider's real security posture.
But providers guard these Type 2 reports closely, right?
They absolutely do. Because it's so detailed, listing controls tested, how they were tested, the results, any exceptions found, it's basically a roadmap for an attacker.
Ah, reveals potential weaknesses.
Exactly. So standard practice is the provider makes the customer sign a strict non-disclosure agreement, an NDA, before they'll hand over the SOC2 Type 2. It balances the customer's need for due diligence with the provider's need for security.
Makes sense. What about SOC3?
SOC3. Think of it as a marketing brochure. It's a high-level summary, often just a seal of approval for public websites. It contains no details about the controls or the testing. It's completely useless for any serious assessment or due diligence. Don't rely on it.
Good to know. Okay, let's wrap this section with a clear distinction. Laws, regulations, and standards. How do they differ?
Okay, quick summary. Laws come from legislatures, Congress, Parliament. Breaking them can lead to punitive fines, even prison time. Think criminal law aspects of II pay.
Got it. Regulations.
Regulations come from government agencies, FTC, SEC, DHHS. They enforce specific rules within their domain. Penalties are usually administrative actions, fines, maybe operational restrictions.
And standards.
Standards come from industry groups or international bodies like ISO with 27001 or the payment card industry with PCI DSS. They're usually voluntary.
Voluntary. Then why bother?
Because following recognized standards demonstrates due care. It shows you took reasonable, accepted steps to be secure. And proving due care is critical in reducing your liability if something goes wrong, especially in a civil lawsuit. PCI DSS is a great example. It's a standard, not a law. But the contractual penalties from banks for noncompliance are so massive, it might as well be law.
Right. And you mentioned ISO 27001 earlier.
Yes, ISO 27001 is the international standard for an information security management system, ISMS. It provides a whole framework for managing security risks and policies. Getting certified is often seen as the gold standard for demonstrating due care globally, and there are cloud-specific editions like ISO 27070 for cloud service security and ISO 27018 for PII protection in the cloud.
Okay, that was a massive amount of ground covered, an essential deep dive into this legal labyrinth. Let's try to boil it down. What are the absolute must-knows, the exam essentials from all this?
Okay, first, IO standards. No 27001 for ISMS, 27017 for cloud specifics, and the 27037 series for forensics. Crucially, remember their standards. Demonstrating due care, they are not laws themselves.
Got it. Second.
Core U.S. laws, ASHI, privacy, security, breach notification rules, GLBA, the safeguards rule protecting financial data, SOX section 404, IT controls for financial reporting, change control, logs, and PCI DSS. It's contractual, driven by payment card brands, huge penalties, not jail time.
Okay, third takeaway.
Data crisis stuff. Understand eDiscovery is a nightmare in multi-tenant clouds. Know that chain of custody is non-negotiable for evidence integrity, leading to non-repudiation, and grasp how cloud's distributed nature breaks traditional forensics. Fourth, audits. Know why virtualization is tricky for auditors. Understand why auditor independence is sacred. And most importantly, know your SOC reports. SOC 1 is finance only. SOC 2 Type I is design only. SOC 2 Type 2 is the one you need for operational effectiveness over time. SOC 3 is just marketing fluff.
Perfect. And final essential point.
Global privacy. Know the PII definitions differ. Understand the opt-in EU versus opt-out US models. Realize that aggregating indirect identifiers can still de-anonymize data. And never forget the EU treats privacy as a fundamental human right, which raises the stakes immensely compared to the US sector-specific approach. Oh, and the data controller's ultimate liability under GDPR.
You know, reflecting on all this, that point about the data controller liability under GDPR it's kind of terrifying. It really puts immense pressure on the cloud customer. Choosing your provider isn't just about tech specs or price anymore.
It's fundamentally a legal risk decision.
Yeah.
And maybe that's the provocative thought to leave everyone with. In this world where cloud data flows across borders constantly, the single biggest legal risk you face is assuming your home country's laws are sufficient protection everywhere else. You absolutely must continuously check your provider's compliance, their contracts, their audit reports for every single jurisdiction where your data might end up. Because if there's a problem, you'll likely be held accountable under the laws of the strictest jurisdiction that applies. Your liability follows the data.
Excellent critical advice. Thank you for guiding us through that. And thank you all for joining us on this deep dive into the legal and compliance foundations of cloud security. Join us next time as we continue Chapter 10, moving into risk management and how to structure those crucial cloud contracts.